Hey, Mike, congratulations on getting the shift program put together so quickly.
Yeah, you know what, a lot of cooperation among all three offices. I think that we have the instructors, I think there's only a couple of spots left, but um, in thinking about it, um, I just started getting back into the shift book and I'm thinking as I'm reading this, I'm thinking, well, this is almost an everyday type of thing that we should be doing no matter what the market is. So I kind of found it interesting, but we'll get those classes done for July, and we'll get it all nailed down. So I'm sure there's a lot of us read the book and put it away and never got back to it, and it's timely reading.
Yep, I pulled mine out of the basement, had to dust off the cover. Hopefully Chris Alston can teach one of the segments.
Sure. All right, so thanks for joining. We're going to get started, but I want to kind of preface what we're going to be doing. Tuesday, CAR is going to release their normal release. They typically make changes or new forms come out twice a year, and that's June and December. And it came out, it's coming out a little bit later than normal, but it's going to be released on Tuesday. And I think when they make these changes, I think overall it's for the benefit of us. And the reason why they're changing them is they're improving. Either there was some issues with it legally or just confusing and a lot of feedback. The forms committee that does this for CAR is probably the hardest working committee at CAR. If you were to contact them and say that you think that there should be a change in one of the forms, they will look at your request. So they get 1,000 requests, and their job is to make sure they go through it. And if they think that's valid, there's fellow realtors on the committee, there's attorneys on the committee. They will make the changes. Now, it might not make it right away, but usually it fits in that June and December timeframe. So let's get started with our what am I doing? Let me get back to this. Can you guys see it?
Yes.
Okay.
Yep.
Cool. We're gonna go over a slide presentation, and basically, as I said, the release date's going to be Tuesday. There are 6 new forms that are going to be introduced. We'll go over them. There are 36 revised forms that is also going to be changed on Tuesday. Now, the good news is, out of the revisions, the purchase agreements will all be revised, as well as the 4 listing agreements. So out of the 36 revised forms, 12 of them is the purchase agreement and the listing agreement. So not as earth-shattering as 36 sounds. So if you want to take the copies of these forms, if you want to look at them before Tuesday, here is the I don't know if I can get it. I'll put it in the chat. Better yet, why don't I, Elaine, I'll send you the copies of the forms, and I'll send them to all three offices
Sounds good.
after this, after we go over this. So,
Thank you.
okay, so if you go online to the CR website, there will be a quick summary form showing all the changes to this. So I don't expect you guys to remember every single thing that I'm going over. This is really just kind of a precursor just to familiarize yourself with what we're going to be doing. But feel free for the to download the form summary, the quick summary as well, and it does have the description of what was changed. So anyway, one of the biggest thing is you're going to see this coming out on Tuesday, and this is a new form, and it's basically it's called the Fair Appraisal Act Addendum. The history on that is that appraisers have been known to discriminate. There's been cases where that's happened, and this is basically a disclosure. Actually, it's an addendum, so it's in the every single sales contract, so that a buyer or seller has a phone number of who they can contact if they feel that they haven't been treated fairly. So it'll be automatically downloaded with every single contract, sales contract, and it's going to be law effective July 1st that it needs to be in the contracts. But you don't need to deals that are in escrow. You don't that are in escrow are fine. You don't need to add it to anything that's pending prior to July 1st. But as of July 1st, this needs to be in every contract. So the form, it's just as important to have it in our transaction as the TDS. So make sure that you include it. The good news is it'll automatically be split out with every RPA and every purchase agreement that you work on. Any questions on that? Okay.
So that's not with the, that's with the RPA. Is it with the listing agreement as well, or just the RPA?
The RPA, the RPA, the RIPA, all of the sales agreements will be in here. It'll be part of this every sales agreement. Okay, and it's a law that it needs to be in, the information needs to be in these sales agreements.
Not with the listing agreement.
It's these 8 sales agreements.
Okay,
Okay.
okay, thanks.
All right. The forms committee got a bunch of inquiries, and they wanted to have a something for commercial properties. And we have it for the residential properties, an SPQ, and they wanted to make a commercial seller property questionnaire. So it'll be anything that's in commercial or anything that's 5 units or above. Remember, the SPQ it goes with the TDS, which is 1 to 4 units. This is for more than 5 units or more, or commercial properties. There'll be a form basically for sellers to complete for their what they know about the property. There was a dilemma when you have a mixed use property that's for sale. Do we use a commercial purchase agreement, or do you use a residential purchase agreement? So what they decided to do, because most of the time we use residential purchase agreements and then do an addendum to make it friendly to include the commercial part of the property. So what CR decided to do was make a mixed use purchase addendum. So it goes to the on the RPA. You could add this mixed use purchase addendum and make it easier to make the offer pertinent. So they added some boxes. You can see in the boxes what's important, and it talks about how many units are going to be residential, how many units are commercial, and then it talks about who's occupying them. They're going to be vacant, things like that. So it's not really that common where you have a mixed use, but it's becoming more and more common where there's units of commercial and residential on a property.
And in this case is when the owner is occupying the commercial property. Is that what it means?
Not necessarily. It just means that there's a commercial space and there's a residential space on the property.
To live
So
in.
it's not just all residential, not just all commercial. It's just what it says, mixed use, where you have both.
Okay.
Okay?
Okay.
All right. Now, we're finding, and we're part of it too, is that we have our own forms that we want to add to a transaction. So this is an advisory that was put together that for the use of non-standard forms advisory. So forms that KW includes, other companies includes, this will be a kind of advisory saying that be careful what's in these forms. For example, if you look at paragraph 4, it could talk about what these forms may have. Sometimes a form may say that when the buyer signs it, they might be waiving the contingencies, might be changing from a writing contingency removals to making them passive contingency removals. So this is just an advisory to talk to your buyers. I think it's geared towards the buyers of what sellers may be putting in their forms or their contracts or anything else in there. But this is for the buyers and the sellers. I think it's more of a protection because the sellers are adding, sometimes they add different clauses and different forms that change the RPA. So this is a advisory, and you as an agent should of course go through any of the non-standard forms that are from other companies or from entities that are doing this. Okay. Any questions on that? Okay.
Yes, I have a question.
Yeah.
Do we need to have a lawyer to review those forms, or advise our clients to have a lawyer to review those forms?
I think it depends on what the forms are, but you always it's always great advice to have their legal entity review everything.
I'm still gonna let her know. I don't know what date it is. I'm still kind of stringing her along. I don't.
What was that?
Next year.
Is there a question?
Hard for us to do it, Barb.
Okay, all right, let's get on to this. Here's another form, designated electronic delivery address addendum.
Pass up.
They added, hey, if you guys are talking, can you put yourself on mute?
So stressed about money, that's just like,
Hello, guys? Okay. This amendment is really for, if you remember when they changed the contract on the RPA, they put an area where you put, as the agent, you put your email address down and your contact information, whether it's text or email. And this really form was developed because sometimes agents left their emails or contact information blank. And this allows the agent to make sure that the buyer's agent, seller's agent have their contact information, because that is now and that for delivery of acceptance, this is the contact information. So this is in case it wasn't done correctly on the purchase agreement. This gives you a simple page to make the correction on that. Okay?
So,
Yeah.
you're saying, like, say we're the buyers and we submit the contract to the sellers.
Which in that contract that you submit to the sellers, you're filling in your everyone's contact, the agent's contact information, the seller's agent email, as well as your email.
Okay,
Or your text.
so if
If-
I'm the listing agent and the buyer's agent just leaves it blank, leaves their thing blank, then I can't go in and add it because it's the purchase contract and it's already been signed. But you're saying then we add this form to add that information in?
Yes.
Okay,
So it's really just a simple, it's a simple correction to someone not doing something correctly.
okay,
And you're getting the information, because remember that the delivery of acceptance, and when a contract is accepted, is when the contract is emailed to that preferential designated contact info. So if you
Mhm.
don't have it, you better make the amendment so that it ties everything together, and then send it, and then you'll be okay.
and then make sure and reiterate to your clients, because this is going to draw a big exclamation point and arrow to the other agent's contact information, that they're not supposed to contact the other agent.
The purpose of this is just strictly so that if the buyer's agent did their job and put the correct information in the contract, then you wouldn't need this. This is
Yeah.
only when the buyer's agent forgets to do it, or it does it incorrectly, puts the information wrong. This is a correction to that issue.
And then everybody else has to sign it.
Yep.
That's my point. Okay.
Yep. Okay. Not that important, but there's two independent contractors agreements, so they just put it together and getting rid of the two independent contractors agreements, just leaving and just replacing it with one. Okay, here's the one that is going to give the most concern, and I'm telling you, we need to set up a separate meeting, a class to do the defensible space and the FHDS, the fire hardening. And they made an improvement. They added a form called the defensible space decision tree. And it goes through the questions of what if this is this, then you got to do this. So I'm gonna just skim through this, because I need an hour just to go over this form, these two forms. So we'll get that scheduled. But anyway, let's get to the defensible space decision tree is based on the two forms on here. So the fire hardening and defensible space disclosure addendum, they changed it to reflect more of like a TDS. And it's not to the best of your knowledge, Mr. Seller. This is yes or no. And if you don't know, there's no unknown. You got to find out yes or no to these questions regarding fire hardening in paragraph 2B. Let's start off with paragraph 1. Basically, for the fire hardening, it's gotta meet the conditions in order to have a necessary to have the fire hardening form. And if you remember we talked about it's got to have a TDS. If it doesn't have a TDS, it doesn't need, if it's exempt on the TDS, the fire hardening is exempt. The other thing is that by law, it should be 1 to 4 units. So if it's different than that, this fire hardening is addendum disclosure is exempt. And it needs to be in either a high or very high fire hazard severity zone. So nothing has changed in this. Those 3 things need to apply in order to have the fire hardening disclosure on there. And also defensible space compliance. So in the defensible space, there's a whole bunch of options and questions. Let's get to that right there. So paragraph 1 talks about the law and whether it needs to be included or it is exempt. And that's those 3 items there. The other thing about, let me go back here. And the other thing about paragraph 2 is that they added this fire hardening vulnerabilities. And it has a yes or no answer. And, anything here, whether, or if you're aware of other the following features on these items. And that could be checks. Now, you could, if you wanted to, include this form, fire hardening and defensible space disclosure and addendum, even if it doesn't apply. That's up to you. So again, remember the 3 things, whether it applies or not. It's got to be a property that has a TDS, is 1 to 4 units, and is also in a higher, very high fire severity zone. Okay.
Right.
Yeah.
So on the last point of those 3, what is our resource? Is it the NHD report?
Yeah, they should have it, or it'll talk to you in this back here about these defensible space decision tree. It'll give the contact information of who is the, it'll get into the local as well as the state. The natural hazard disclosure statement, companies are putting whether it's in that zone or not. It goes on further with these items here, and we'll get to that in another couple pages, whether there's any local jurisdictions and specific requirements from a local perspective, not just the state. So here's an example. In paragraph 3C, we talked, well, 3A talks about local compliance requirements. First question it asks is property is or is not subject to local vegetation management ordinances. Okay, how do we find that out? We need to call. Who's the jurisdiction for your property? Once you find out that it's in or not in the local and then the state, then there's going to be 6 different options for a buyer or seller. Number 1, buyer's going to be responsible for fixing everything up, and there's no local ordinance. Number 2, buyer's going to be responsible, and there is a local ordinance in effect. Number 3, buyer's responsible, local vegetation management ordinance in effect, and one is a due on sale, on the sale, and the other one is not on the sale. That'll be done after close of escrow. And then there's 3 sellers where the seller's responsible. Again, I don't want to get in the weeds on this right now because we really need to spend a lot more time and there'll be a lot more questions. But I just want you to be aware that on Tuesday, you got to take a look at it, and we'll set up another time to go over it. And let's see what else. I talked about the defensible chart. Actually, that was in the right here, the defensible chart, and it takes you step by step on the decision. It's called a decision tree, and it takes you from paragraph 1 through all the other things. And I just put it to the side when you're looking at this form. Put that defensible space decision tree and go through it.
So is this form automatically populated in our agreements now? We have to go find it, the tree.
It's not automatic because you don't need it if it's not in a very high fire hazard zone.
Got it.
And you don't need it if it's an excluded TDS. Or if it's not 1 to 4 units. Any one of those 3 things exempt this form.
Hey, Mike, quick question.
Yeah.
You have to call, you said the local fire department, right? To find out whether or not.
Well, I don't know if it's the fire department. It depends whether the jurisdiction is.
Gotcha.
And in this, I'm looking to see, well, I mean, it's got the state information on here, but it doesn't have the local jurisdiction.
Okay.
All right. All the agreements, the purchase agreements are all amended to reflect that very first thing that we talked about, the Fair Appraisal Act. So every contract is going to have this paragraph B3 included in all your purchase agreements. And you see the check marks, so it ought to be automatically be spit out with the rest of the contracts. Okay. Whether there's an appraisal contingency or not, it doesn't matter. This form will be included. The other thing that was changed, and you know, really it's not that significant, but I think it is a significant thing and a decision that that Sierra decided, was the attorney's fees clause in our listing agreements. In our listing agreements, the prior to this revision, if there was a suit between the seller and us, we had the same attorney's fees clause as the purchase agreement, which was the prevailing party got their attorney's fees paid for by the losing party. That's what's in the purchase agreement. CAR kicked this around and thought if we have the same paragraph, it might lead to more potential lawsuits from the seller suing us as the real estate company. And by changing it to that each party has to pay their own legal fees, it would cut down on the lawsuits from the seller against the real estate company. So that's the change in the listing agreement, that all the parties, basically the seller pays their attorney's fees and we pay our attorney's fees. Okay. Also in the agreement is got this representative capacity form that and the paperwork here and the signatures in here, just like if you look at this, it's exactly like the purchase agreements. Now it's going to be added to the listing agreements, so we could eliminate the representative capacity. We don't need to spit out that form because we stopped using that form when we have a purchase agreement. Now we don't need that form because we have this verbiage in here. We can eliminate the representative capacity agreement for our listings. Any questions on that? So if we're doing a listing with a corporation, we don't need that representative capacity because it could be handled right in the listing agreement itself. Okay. Another change. Request for repair. So what we have here, and I got a feeling we might start seeing more of these forms, but it just makes it easier to negotiate on this request for repair. Number one, it still gives us the right to remove to remove the investigation of the property contingency, as in paragraph 4A, or the option, you could remove whatever contingencies you want on a contingency removal form. Okay, that's the first thing in paragraph 4. And then paragraph 1 in the seller agreement, A, B, C, and D, it makes it easier to what the seller is agreeing to. So a seller agrees to all of it. Seller agrees to all the buyer's requests except for, it's a partial, except for this, and this. Paragraph C is additional conditions. Then you could check the box if they want, the seller will agree to it only if they agree to do additional conditions. And that could be whatever it is. And it just kind of details it out a little bit better than our existing request for repairs, and just makes it so that seller and buyer can agree on the request for repairs on this one form. I think it just cleans it up a little bit. It still has 2, 3, and 4 where you still can go with a response to the request for repairs in paragraph 2, where the seller's responding to the buyer's request for repair. Or you could do paragraph 3, a separate addendum that the seller can give, or paragraph 4 is that the seller does not agree to any of the requests. So really, paragraph 1 is the one that's really changed and kind of makes it easier to for the seller to put what he wants to do to the request for repairs. It'll be easier if you guys have it in front of you and you have the whole form. It'll be almost self-explanatory, but you just go through it and we could review it together. Cancellation of contract. So paragraph 1, this paragraph is going to be used if one of the parties cancels or wants to cancel. And I'll give you an example. You give a notice to perform, seller gives a notice to perform, buyer doesn't respond. This is where this cancellation of contract and deposit and cancellation of escrow, you could have the buyer or the seller. In this case, my case would be the seller would be signing below, canceling the contract. They also added paragraph B, which is you could check the box, which is a proposed mutual cancellation by signing on the next page, where you have all parties signing that. So it's just talking about the one party cancellation or mutual two-party cancellation. That's in paragraph B. So if it's a one-party cancellation and say the seller under my scenario gives a notice to perform, buyer doesn't respond, seller wants to cancel, seller does this one-party cancellation, and the seller signs. Actually, whoever is doing the one-party cancellation is the party that is signing and canceling the contract. So in this case, the sellers would sign both would sign these lines. The next part is the deposits, and it's the same as what we had, except they added a paragraph 4, which is if there's no deposits in escrow. Usually, what we would have done would be other, and we would say no deposits made. This is just formalizing it, so you just have to check the box without having to put words in here. But everything in the everything else in the cancellation contract remains the same, but they added those couple changes. Okay. Let's talk about the probate agreement. And this is part of the addendum that goes on to a probate agreement. Now, most of the time, you have two choices. Either it's going to be no court confirmation required, or there's court confirmation required. Even if there is no court confirmation required, there could be a court confirmation can be required, and that would happen if the heirs legally they have 15 days from notification to either approve the sale or contest the sale. If the heirs contest the sale, there needs to be court confirmation. I have an escrow right now where I said no court confirmation. The only time it would be court confirmation is if the heir objects to the sale. And this is adding verbiage that is saying that there's no court confirmation. However, if there, by law, an heir has the right to contest the sale, and then there would be court confirmation required. And if there is court confirmation required, you notify the buyer. The buyer has the right to cancel the contract and get their full deposit back. And that's what's added in 2 and 3. Everyone understand that? There's generally there would be no court confirmation, but it still can, even with a no court confirmation, it can be thrown into a court confirmation if an heir objects to the sale. That's why the verbiage says may. That's why in the MLS it'll say may have court confirmation. Well, you don't know, even though you tried to figure it out. There is that chance that even though there's a court confirmation is all handled, wasn't going to be done, that it gets forced into that. Buyer has the right to back out and get their full deposit back. That's what's added in the probate agreement purchase addendum. Just a reminder, they remove the probate purchase agreement and just made it part of the RPA with the checkbox to add the probate purchase addendum. So anyway, that's what's changed on that. Seller multiple counteroffer. They changed that to reflect that when the seller sends out multiple counteroffers and then the buyer signs it, then in this box, paragraph 8, the seller needs to sign one of the seller multiple counteroffers to make it a formal transaction. So in a seller multiple counteroffer, nothing's changed in this. So you always needed another signature on a part of the seller to make that multiple counteroffer part of the transaction, so you have a completed transaction. What they've added is an area to make that seller multiple counteroffer a backup offer. So you could have seller multiple counteroffer and accept multiple counteroffer 1, and you want to make multiple counteroffer 2 a backup. You could do it now on the seller multiple counteroffer. Now, when the seller elects that the backup offer, it will require the buyer to sign that after the seller signs it, to be in agreement that they want to be in the backup offer. So the only thing changing to the seller multiple counteroffer is that they are adding a spot for that multiple counteroffer to be a backup offer, not to be the accepted transaction, but you have the possibility of making that seller multiple counteroffer a backup offer. Any questions on that? Everything else is the same. Seller sends out a multiple counteroffer. Buyers need to sign it or counter the counter, and then if the buyer just signs the multiple counteroffer, it takes the seller to re-sign it to make it an effective transaction and be part of a meeting of the minds. This is just adding the backup ability on the other counteroffer. Any questions on that? Listening to myself, I think I made it sound a lot more complicated than what it really is. Okay. Next one, SIP agreement. This is more of a CYA. And what it's saying is that the party needs to talk to they should get legal advice on what is involved with a seller in possession addendum. For example, let's just read the first block. There may be some local rent control, and regarding tenants' rights may impact the buyers and sellers' rights. So there could be interpretation, although we try to avoid it with the seller license to remain in possession addendum. We try to avoid that. It's not a landlord-tenant situation, but it's a license to stay in the property. The second block, which is in green, is what happens. We know that 29 days should be used for the SIP. What happens in day 29 and the seller needs a couple more extra days? Now, does that change the rules and the rights of the seller? Now it's more than 30 days. Does that give them tenants' rights? This is saying that we don't know if it creates any further rights or not, but we encourage the parties to seek a legal counsel. What we do now is just simply, it's supposed to be 29 days, and the seller says, I need 2 more days. You get an addendum, and you're saying seller shall move out, 2 days from or on June 30th. Don't know if that could be now argued as a landlord-tenant relationship. We don't know, and the tenant should get some if they feel uncomfortable, they should get some legal advice on that.
Mike,
Yeah.
so if they need the extra days, like say they need a week, we can just do an addendum. We don't have to do that other longer form we don't have to restart that other longer form.
No,
New 7-day added date, right?
I never did that before. I would just add 2 extra days or extra week or whatever. This is now saying just in the SIP agreement, it's letting the buyer and seller know that we don't know whether there's a landlord-tenant relationship, if it's created or not by changing the existing SIP. But no, you don't go to an SIP at the 29th day and change it to a RLAS. Any other questions before we go on to tenant occupied property addendum? Here's the one thing that's changed. With the tenant occupied property addendum, the paragraph 3 is saying that if there is a tenant occupied property addendum, if the seller is going to stay after close of escrow, the default is that the tenants are going to be removed at the specific time as to when that's going to happen. Except in it spells out who's going to be there. So basically, in an SIP, if a SIP or RLAS is used, it's just the seller to remain in the property. If in property that is, hold on one second. Property A is tenants to remain in possession, or B, the property is going to be delivered vacant. And then let me go back. The 1A or 1B says that if the seller is going to be staying, after close of escrow, the seller can stay in the property with with an SIP or RLAS. It is not for the SIP or RLAS is not for a tenant. If paragraph 2 talks about it, then that talks about if the tenant's going to be staying in the property. We know then that when this came out last year, a lot of attorneys for the buyer did not like this form, because basically what it said was on the TOPA was that if there's a need to be filled out, regardless if the tenant was going to move out or be in there, when the deal was accepted, it needed a TOPA. And this form basically says if the tenant does not move out, it's a buyer issue. Seller washes his hands on this. So anyway, you got to be careful about this TOPA when you're dealing with tenant occupied properties. But they added this this SIP TOPA to make sure that the SIP is just with the seller. Seller property questionnaire. The first thing that it really talks about, it talks about that if there's history of repairs, some events that took place, is the responsibility of the seller to disclose those past events. Number 1, that's paragraph 4, seller awareness. No matter how long ago, it's still required that the seller needs to disclose. The paragraph 6 talks about whether there's a death in the property, and also talking about the manner of the death is important and should be disclosed unless it's HIV death, which is, it's against the law to disclose that. So it's just talking about that not just the requirement that if someone died in the property within the last 3 years, also that the manner of death, not just the death, should be disclosed. Any questions on that? So the one time you cannot legally disclose the cause of death is what? What is the death?
AIDS.
HIV.
HIV. Okay, cool. That can get you in a lot of problems. Okay, paragraph 9 is regarding,
I'm sorry, Mike, I do have a question, sorry.
sure.
So if it's mandatory to say the death.
No, it's not. I never said mandatory. I said
Cause,
it should be disclosed.
oh, it
The
should be,
reason why it should be disclosed, because a lot of buyers in different ethnic
beliefs, a lot of different
yeah,
beliefs, yeah.
yeah, so
Uh,
this is just disclosing to the seller that although you fulfilled your legal obligation, you should disclose the cause of death.
Oh, you should, well, that's
Yeah.
kind of broad.
Well,
That's
I mean, just read it. The manner of death may be a material fact to the buyer and should be disclosed. So when they're talking about the manner of death may be a material fact.
You
For
mean
example,
like,
would-
so I would
would the-
think some, like suicide or
Would a
murder,
would a murder be a material fact?
yes,
I would say so.
yeah, and then, or, okay, well, but
So
we,
it's just adding to it and just pointing it out, because the old form just says, did someone die in the property? And that's
no,
it.
I know, but that kind of leaves it a little broad. But anyway, what I was gonna say is, so if we don't say, if the client doesn't say something, then we're kind of led to believe, well, then it must be HIV. But anyway, it's just
No, not necessarily. I mean,
just a comment.
I would say, Yvonne, if you asked the question
Hmm,
and the person said, I can't divulge that,
yeah,
then you assume HIV. If someone asks and someone says, I'm not, you assume it, but not necessarily. I think it could become a legal issue if someone died of suicide and you asked, and a buyer asked whether the cause of death and the seller refused. I think that there may be some legal issues that the seller may have.
so us as listing side, we taking the listing, is it our obligation if they say yes to ask them what was the cause of death? Is
Well,
that,
if a buyer's agent asks you, then yes, you need to ask the seller what was the cause of death.
right, but just having a conversation with the sellers at the listing, whatever, anytime during our listing to get it all started, is that something that we as a listing agent should be asking?
Um, yeah, I would ask that, because I would want to know, should we go step further to keep your seller out of some potential legal issues?
Protected. Okay, thank you.
I mean, if it was a murder, yeah, they should disclose that, because I feel that's a material fact.
Yeah,
Yeah.
If there's I think that a suicide needs to be disclosed personally. But I get arguments across the board from other brokers as well as sellers about that.
So basically you could say to your seller, you're legally obligated to answer all these questions honestly. And if the death and report a death and the cause of the death, unless in the only instance it's from HIV/AIDS. Right.
What I would do is I would say, that you, Mr. Seller, are required to disclose all the material facts on this house. Period. And it could be viewed that the cause of death could be viewed as a material fact.
It happened to me that I was showing a property to my buyer, and we were talking to the neighbor, and the neighbor told us everything about the death in the house we were looking at. And it was never disclosed to us before. So it was a problem because we were going to make an offer, and thank God that this neighbor told us, because they will know. They will talk with the neighbors, so they will know. So they need to know. It's important.
Yeah, okay. Paragraph 9, this is just saying that if the house has flood insurance, it might be a condition that to buy the house, you might need flood insurance. And paragraph 14, more questions about the condominiums. It more questions on the condominiums as the SPQ. Okay, and here we're back to this fire hardening and defensible space advisory, and it's 2 pages, and just advisory language, and it talks about where to locate information on here. And it mentions the Natural Hazard Disclosure Company, or it could be from a local fire agency. It goes in more in detail. So, and it talks also about even though it's not required, seller may still want to fill this out completely, even if it's not required, because it might be viewed as a material fact that the seller wants to kind of CYA. But we'll get into that, and we'll get into that another hour on that. The next bunch of forms will be an RPA cleanup. There'll be a bunch of property management forms. And the other thing is the buyer broker agreements will be coming out. Those are the buyer broker agreement will be the big changes on the forms in the next release in December. So it's not major like they did with the new RPA when they made that change, but just added some cleanup things and a couple other minor things. It shouldn't stop anyone from being uncomfortable on selling real estate, but you need to be made aware that there are some changes and not significant, but there are changes to what is happening today versus on Tuesday. Any questions that you guys want to go over? Any general things that you want to discuss? I mean, I covered it. I wanted to cover it in an hour. And that's without going through the fire hardening thing, which is going to take a whole hour in itself. Mike,
can you hear me?
Yep, I hear you fine.
So a question on the repair request addendum where
Okay.
it's the item is to removing their contingencies or providing the contingency removal. On the box above that, it says removing the contingency when by the seller accepting the buyer's request. Does that automatically remove it, or do we still need a contingency removal form?
Well, I don't have it in front of me right now, but basically you're talking about the buyer's investigation.
The request for repair addendum.
Yeah, and it says that the buyer removes his investigation contingency.
Correct.
Yeah, you don't need it. but I would like to have it included when the other, just, you don't need it. To have that contingency removal because you're using the request for repair. But I would like to have it just to clean it up when you do the other contingency removal. Make sure that you have all contingencies removed.
Yeah, but that's what I was thinking, but I was wondering if by explaining it to the buyer that it's automatically removed, right? That by
Yeah,
them
because
accepting it, it's enforceable.
If the buyer and the seller agree to the request for repair, then it's removed.
Okay, thank you.
Mhm. Yeah, anything else? 3-day weekend.
Oh, yeah. Hey, Mike, I just saw Terry's chat. I had to do a defensible space up in Arnold. CAL FIRE was the resource and they were great.
Good.
I can should I just send it to you, Mike, the form?
Sure.
Okay, I'll send it to you and then you can pass it on.
I'll
Check
distribute
it, check it first.
Yeah, okay.
It was earlier this year that we, and they were great. We just asked them to come check. They checked. Thankfully, we were all good. They issued the clearance and that was it for us.
Nice, nice.
But I'll send it to you.
Appreciate it. Hey, I brought up the 3-day weekend just as a reminder that the offices will be closed on Monday. But if you're working, just go ahead but there won't be any staff Monday.
Mike,
I'll
in
be
terms-
here, but I'll be working.
Mike, and for the fire, I also had some listings where where an HD said that the home is in a high fire zone, and then the fire department, the local fire department, was able to issue a certificate saying not applicable.
Nice. Nice. You know, it's still, these natural hazard disclosures, companies are still kind of getting through this. And we might have some, it's a good idea. I'll go to just double check to make sure. One question though I have, I'll get, if it's not a local ordinance, it still could be, there's a possibility it still could be state, right?
CAL FIRE, yeah, that's
Yeah.
where CAL FIRE was able to help out as well.
Perfect, good.
If you're looking at these were, it was a specific area in Bay Area in the middle of the city, not in the mountains, not in the foothills. So I was shocked to even see that on the NHD. Anyway.
Got it. Got it. I'll stick around a couple more minutes, guys, if you have anything else or any other questions, and everyone else, have a great weekend. Be safe and enjoy your time.
Thanks, Mike.
Happy Father's Day, Mike.
You too.
Thanks.
Thanks, Mike.
Thanks, guys.
Thank you. Happy Father's Day.
Thank you.
Happy Father's Day, yeah.